Hello, everybody. Adam Parks here with another episode of Receivables Podcast. Today, I'm here with an industry expert on the litigation and debt buying, and hey, one of my best friends as well, Mr. Neil Mastellone, who's joining us from Velo Law. How you doing today, Neil?
Good afternoon, Adam. Doing very well.
I really do appreciate you coming on and sharing some insights with me. We were talking recently at one of the conferences about modeling costs and really talking about the return on cost modeling from a litigation standpoint and what that ultimately means for a law firm, for a debt buyer, and the different investment strategies, and really just the different perspectives of creditors versus debt buyers versus the law firms as you're going through that process. So really had such an interesting conversation in person that I wanted to share that with the industry here and talk a little bit more about it. But before we jump into our core subject today, for anyone who hasn't been as lucky as me to be your friend for the last 10, 15 plus years, could you tell everyone a little bit about yourself and how you got to the seat that you're in today?
Certainly. Thank you, Adam. I've been in this industry now coming up on 20 years. I got my start brokering debt sales on behalf of banks and debt buyers. Following that, I moved to an outfit that was buying files as principal, and we were selling through primarily an attorney purchasing network, state sales, regional sales, things like that. That marketplace became a little bit more difficult to work within in the early 2010, 11, 12 period. And I made a move into compliance consulting, did quite a bit of work in that space, drafting policies and procedures as well, doing some vendor auditing, developing processes for these, and sort of traveling around the country, helping people to come into compliance with sort of an ever-changing landscape of regulations. After that, I started a little debt buying company in the Southwest, and we grew from a one-state footprint to buying in I think it was at the height, it was about 36 states. Yeah, and managed a vendor network of agencies and attorneys, and still spend some time in that space, but primarily now my time is dedicated in the business development function at Velo Law. We're a collections and creditors rights firm in Grand Rapids, Michigan. We're servicing a footprint in the Midwest, Michigan, Indiana, Ohio, Montana, and most recently Wisconsin. And so we're working with accounts receivable management companies, creditors, debt buyers, and really anyone extending credit on behalf of a business.
Fantastic. And look, your experience is storied. I've had the opportunity to work with you in a number of those different locations throughout the years. So I'm very excited to have this conversation today. So really where I wanted to kick this off was you've got a really interesting perspective on this cost modeling and trying to understand it from the different perspectives. And I think those perspectives are mostly focused on the creditor, the debt buyer, and or the law firm that is working those accounts. Talk to me a little bit about how you see cost modeling from a litigation standpoint being viewed differently between those three marketplaces or those three disciplines.
Sure, right. I mean, in so many situations, it's important to know who the audience is, right? I guess in this case, it's important to know who the speaker is. So, I mean, are we speaking on behalf of the credit grantor or the credit issuer, where collections and collections through litigation might be a loss mitigator when this particular account is just one that we cannot bear to not collect? So, okay, we're going to invest in the litigation of this particular account. Is that the perspective? Once that title changes hands and now this file is in the hands of a debt buyer, the perspective is drastically different, right? It goes from being a loss mitigator to central to the revenue generation operations of the company. And so the perspective around what is worth investing changes immensely, right? And then the question becomes, how many of these accounts can we qualify for suit? Then if you make the move over to the vendor side, you have arrangements worked out with your clientele, presumably on payment terms of some kind, but most of the vendors are going to be advancing their costs. And you can lay out those terms as well as you want, but ultimately you're sort of subject to the wherewithal of your client. Are you just the Bank of Neil now and you're going to lend me costs indefinitely until such time as I start making money and I can pay you? Am I sending you every single account I have and you're going to sue great guns on it and we're going to spend the next however many years trying to recover that? Or are we much more target selective? As the vendor, you got to know those things about your client, in addition to the terms you lay out, right? So I think depending on what chair you're sitting in, you're viewing costs and the justification for those costs very differently.
Fair statement. So, as a debt buyer, if you're a debt buying organization that has litigation in the model, you're going to have to fund it from somewhere. And I've talked previously, and you and I have had this discussion through the years about the different layers of debt buyer funding. You have those that are doing specialty finance, you have the private family and friends money, and then you have the syndicated bank lines. Those that are the larger purchases are generally working through these syndicated bank lines. And when you're thinking about it from a debt buying perspective, how do you view this cost modeling? Right? Is it a function of balancing the accounts that I'm going to litigate against the cost? Like, how do you view that from an investment strategy standpoint?
So again, I think it pays to outline the not the speaker in this case, but the approach, right? Have I borrowed this money from one of our debt buyer financing companies, or maybe I'm fortunate enough to have more conventional financing arrangements available, wherein the general portfolio of the company or just sort of our pool of assets and cash flows is going to fund this court cost effort? Or am I on more of an investor, I don't want to friends and family, but just, investor specific model wherein the monies for this portfolio that are paid out of this portfolio must be paid back by this portfolio. If the costs and the revenues need to be segregated in that way, again, that's gonna change your perspective on timing, right? Because you can go quite a bit faster if you've already got the money. I mean, I don't think that's not too surprising, right? If you've already got the cash flow coming in, you certainly can proceed much quicker.
Sure. Well, you don't have to cream the top of the portfolio in order to generate the cash flow that you need to invest in the litigation. So you can focus more on your core strategy instead of having to blend strategies specific to generate cash flow.
Well, there's also an argument to be made that you can borrow less, right? I mean, if you're borrowing just the value of the portfolio, you are not financing in these court costs. Presumably you need more cash flow out of the gate to fund that. But if you're drawing on that existing pool, you have a lower servicing obligation on your financing, and it might make things a little bit easier for you. I mean, surprise, it's better to have more money.
Surprise, surprise. Look, from that perspective, there's multiple financing opportunities here, and sometimes the special purpose vehicle or the investments need to remain separate and are more portfolio based, and other times they are blended, right, across a variety of portfolios or even cross collateralizing portfolios, to that regard. So I think that there's a lot to be said for that area. But as we start looking at this modeling and we start thinking about how quickly are we going to be able to move down the path, right? It's the cash flow, the timing of the cash flow, and the risk associated with that cash flow. So how much cash flow can I draw from this pool? What's the timing of it based on where or how I'm funding those court costs? Do you find or have you seen more organizations financing those court costs, or what does that look like out in I realize that there's multiple options, but what does it really look like in reality in the marketplace?
So at the vendor site, I think you always need the ability to finance court costs, right? I mean, in a perfect world, you're bringing on a lot of volume, right? And so you've got a lot of suits to file, and you're going to need to spend this money before you make it back. And so in that case, I think it pays to have robust credit lines to be able to do that. The terms that you have worked out with your clients and diligent or what's the right way to say this, how well that's being enforced, right? Like how well they're adhering to those terms is gonna determine your comfort level with advancing those costs. If you've got everybody on 30-day terms and everybody's paying on 30-day terms, well, hey, you can sue anybody you want.
Mhm.
But if, on the other hand, your clientele are growing debt buyers, or maybe you understand their business models well enough to know that, you know, everybody wants all the files that can be sued as quickly as possible, but not everybody can support that, even if they want to think they can, right? So it pays, I think, as the vendor, to kind of pump the brakes periodically, especially when you have clients that periodically place a more modest amount of accounts, and now all of a sudden there's a big spike. Good for them. Maybe they made a great deal. Maybe it's the opportunity of a lifetime. But let's make sure that everybody knows what kind of bill you're going to run up here.
Let there be no surprise down the path. In other words, don't execute on everything before they truly understand what they're in for, right? If they're going to catch a $500,000 bill and they're averaging it, 1,500 a month, like you need to really communicate. So it sounds like the communication of the process itself and setting that expectation on behalf of the client, wearing the vendor hat, right? Like, but setting that appropriate expectation on behalf to with your client would be mission critical. Like you need to have that in place in order to avoid the explosion of them realizing that they're out of cash.
Well, and I think that a lot of this can be addressed very early on in a relationship,
Mhm.
but it just requires periodic assessment. I mean, in
Sure.
theory, these companies are growing. The wherewithal to do this should grow with it.
But
And
you're managing an exception, right?
that's it.
If you're seeing a spike that's coming out of nowhere, you're immediately starting to assume that a lot of different things. But when you see that spike in volume, now you're concerned with, okay, this is an anomaly. This is outside of the normal course of business. Like I need to communicate.
Yeah. And I think just having a mechanism in place to identify larger activity coming down the pipe. And then thankfully in the legal process, well, thankfully is a questionable, but the legal process doesn't happen overnight, right? So we have a little bit of time to make some of these determinations. And then as well, there's no, unless you're up against statute, right? There's no law that says I must sue these people right here and right now. So perhaps it's just a matter of pacing. And then, but those are all discussions that need to be had between the vendor and the debt buyer or the creditor. You're not just hiring a contractor. Just go do it however you think it's done best.
Sure.
This is in theory an extension of your business that you are still responsible for managing. So, I think having that collaborative relationship and a back and forth, a very candid back and forth, really about costs and remits is not only nice to have, it's requisite.
Agreed. I think having that conversation in place is very important. Now let's think about it from a creditor perspective. The creditor's got a very different hat on because they're not necessarily chasing the dollars, they're trying to save dollars. So I guess the question starts going down the path of how much makes sense for the creditor. Are they willing to take the same risk levels wearing that originating creditor hat with the point of view of I'm trying to mitigate my risk versus someone who is invested in the debt buying portfolios?
Well, I think that's a candid no. I don't think that they would. I don't think
Like
they
the
have
creditors
nearly
aren't going
the
to sue
incentive
everybody.
there.
Like we
To,
know that, but how different are those two worlds?
well, I would say they're night and day. I mean, I think on the creditor side, you're assessing like, is there no way we can do this other than suing this person? And on the debt buyer side, once you've run your voluntary collection efforts, it's almost as though you say to yourself, well, how much of this file can we qualify for suit? Right? Because
Okay.
there's where your recovery is. So I think they're opposites. The bank and the debt buyer has this problem too, but the bank has it in a much more tangible way. They're also dealing with headline risk in
Mhm.
a way that you're not. They might want to preserve a relationship with this customer. They might want them to open a checking account in the future or something like that. And so, the determination has to be made. Do we want today's money or tomorrow's money? Is it going to be worth investing in something that is already a loss?
That's interesting. From a creditor perspective, it is very different, and the timing of those cash flows seems to be different as well. When we're thinking about the litigation, I know I've talked with some groups that are like sue everything, or the law firm is suing everything that's coming in house. And I guess have you seen a change in the balance between who's driving the decision making? Everybody these days talks about data is driving the decision, but do you find it to be more about the debt buyer and their data or the law firm and their data that is in the driving seat of deciding which accounts to litigate?
So I think I got to give you a mostly answer.
Of course.
Mostly, I'm finding that the debt buyers themselves are doing a lot of the selection before they ever send us the account. There, there may be some accounts that we would qualify for litigation before they would. I mean, generally speaking, the vendor's usually willing to sue more people than you are.
Fair.
I mean, if you're willing to pay for it, just they'll sue them all. So you know, so that's definitely something to keep in mind. I would say that that the bulk of your debt buyers, and the more successful ones and the ones that are going to be here year after year after year, are the ones that are going to be more judicious with that cost dollar. And they're going to be the ones that are going to send you an account only because they think there's a very good chance you're going to collect it through this litigation process. And whether that's because they've identified an asset, or they feel very good about an address and you're dealing with a person, for whatever reason, that there's a sense that that is a liquidable account and not just that's an account we own.
Right, there's something else an additional characteristic has been identified in the account that would lead you to believe that account will liquidate.
Right. And then there's a smaller portion of those clients that are going to send over, anything that didn't collect in the more traditional collections process, right? And then, ideally, you're collaborating between the vendor and the client to say, okay, well, these accounts for suit, you pull them back from that agency and send them to the law firm. And then in that case, yeah, they're suing everything they get.
It feels like the debt buyers have become significantly more sophisticated when it comes to their data management in like really the last 5 years. I feel like prior to that, there was more of the law firms driving some of the decision making. Once you've gone through your traditional collections, we'll kick it all out to the law firm, identify and whatever. But it feels like that has shifted pretty significantly in the last 5 years to where the debt buyers are really starting to get into the data sciences. They're buying more data, they're appending more data, they're making decisions in advance of. That was my experience, kind of being on the debt buyer side. And maybe that's because the gentleman that was running our litigation department is a data junkie and just absolutely loved the data and was really hyper focused on what is going down each channel. Because if an account that's prime for litigation may not even go down the traditional collection channel, and we're moving the other products down that traditional channel to identify those opportunities to liquidate. And so there's a couple of different ways that organizations can approach these challenges. But it feels like the data has become a bigger part of it. The supplemental data, the understanding of what is within these accounts. There was a time where we would look at a whole portfolio of accounts in a spreadsheet, and you could kind of pick out some of the things that you thought high level were going to fall down the individual channels. But I think we've learned over the last 10 years or so that our assumptions were anecdotal at best, and now there's a data set that we can run behind it, and then there's all of these waterfalls and data vendors that we can ultimately use to supplement that data process and establish a stronger correlation between our predictions and the outcomes of the accounts themselves.
I would agree with that perspective completely. I think a lot of it has to do with the availability and the ease of accessibility of some of this data. And I would say if you're not a data junkie, you at least need a data habit, because
Like that.
I think those folks are able to put that data into use on the operations side. That data came into use on the acquisitions piece before that file was ever purchased, right? So the determinant of what to pay for that file gets driven by that data. So naturally, I mean, if you have a litigation model and you're saying, well, I want to buy this file because I believe I can sue this many people within it, and I believe of those people I can collect this, the better my data is for driving that decision, the better price I can support. Or maybe I see a giant red flag that I would not have otherwise seen, right? And maybe I need to pump my own brakes, right? But either way, I think that people have command of so much more information now that we can really, as the debt buyer, we can be a value add in that process, right? It's not so much that our whole value is we own this debt, right? So now we are an operator between creditor and vendor instead of just a holding place for the title to a loan. That the data is now being improved based on who owns it.
Mhm.
We have a lot of folks in this industry that are smaller, some of them not so small, debt buyers that are themselves collection attorneys. That's a situation where they might be as successful as they are because they were one of the first entrants into collecting this data. They were closer to the data in the first place. And now that it's more widely available, people are wildly creative when it comes to ways to model around charge-offs. I've been very impressed with some of the moves people have made.
And operationalizing those data sets. So if we're going to try and assume, or if we're going to predict which accounts we should be investing in from a court cost perspective, like if we're thinking about our return on cost from a litigation standpoint, One, I think the data needs to be included in that calculation. Like if we're talking about what is it costing us, or what's our return on investment or our return on cost from a liquidation standpoint, aside from the cost of the account itself. Like if you're viewing it as a debt buyer, aside from that, from what you paid for the account, right? Like that's your target, for break even. But I feel like there's some interesting challenges here from a debt buyer perspective, and really trying to understand, how do you optimize this flow, and how do you ultimately predict, not are you going to win in the suit? Because that's not really the equation here. The equation here is, what kind of liquidation am I going to be able to get once that judgment is in place? Am I going to be able to find a job? Am I going to be able to find a bank account? Like, what data set am I going to be able to find at that point? And then who ultimately is responsible for that part of the process? So we talked about modeling those court costs, but what about that data set on the backside? Is it the law firm that's responsible? Is it the debt buyer? And I realize it's contractual, but I'm curious to get your take on an appropriate approach to that balance.
So, so many times the answer is always the same thing. And it comes down, yeah, unfortunately, right? It comes down to communication. So there are those vendors who are going to very diligently move your accounts through waterfalls. You need to flesh that out as you're vetting that vendor. Where are you sending my data? When? How often? Based on what criteria? Because you might not be as anxious as I am to get that stuff into a waterfall. Maybe you're up against your own cost constraints,
Mhm.
right? But that's my asset. So I need to know that it's getting to as many places as can help me identify information that will assist in the liquidation of that account, providing that I can keep that data secure, big capital P, right? Provided I can
Sure.
do that. But I need to know that it's getting as much of that attention as it can possibly get. So if you have a relationship with your vendor wherein you feel very confident that it is hitting these vendors at these intervals and that effort is sufficient for your purposes, then okay, you have a comfort level that a lot of people don't have. But I think what ends up happening is you end up supplementing your vendors' efforts, right? There are some data vendors that we're all going to use. And so if you're going to use them, then I'm not going to use them, because why are we going to do double work? But there might be somebody who you don't use just because you don't have a relationship with them, or, for whatever reason, that I do and that I've had some success with. So if at the end of your efforts, if you haven't found someone through your channels, I'll try mine, you know, unless your relationship with the vendor is, look, we file these suits, we get you these judgments. If you want us to garnish, you got to send me employments. If you're doing all of it, well, then, yeah, you're going to have to set up the entire waterfall yourself. But again, you ought to be fleshing this out pretty early on.
At the beginning of the relationship, not at the end. Right? Like
Yeah,
not once the accounts are already in place, but like, where, like, if you flush this all out in advance, you can set yourself up for a very successful relationship.
I think so. I think you give people a chance to honor their commitments when when the conversations are more realistic.
So I got one more question for you here, Neil. And it's, this is a hard one really to answer as someone who has been on both sides of the fence. But from your perspective, what advice would you give to other debt buyers that are placing accounts with a law firm in terms of improving their return on their costs?
Turn on their costs.
Having lived on both sides of that equation, I'm just curious as to what advice you would give others to go out and execute. We've talked about the differences, and we've talked about the why, the where, and the how, but like, what advice would you give them to send somebody on the right path for success in this area?
So I think you need criteria to file a suit. You cannot say, based solely on the fact that someone owes me X dollars or more,
Mhm.
I'm going to sue you. It's inadequate. You're going to lose.
Agreed.
Not in the litigation matter. That strategy will not succeed.
Okay.
There's got to be a reason you think you can collect this account, right? I have a good address. I'm going to get a judgment. This person is 30 years old. They can't be unemployed forever. There has to be a reason why you think this account is liquidable. The more reasons you get, the more confident you can be in that investment. Those reasons cost money, though,
Mhm.
right? So verifying that information can be costly. Again, if you have a vendor that you feel like is doing a lot of that work, maybe you can have them have more of a role in the suit selection. Some vendors are going to be excellent in that regard. You're going to find that there are some people that are your right hand when it comes to who to sue and when. Ultimately, though, and I say this as both debt buyer and the representative of the vendor, as debt buyer, that is your asset. So ultimately, the only person who's really going to be upset if that account doesn't collect is you. So you've got to be driving the bus on information. If your vendor is unable to liquidate an account, if they're doing everything right, they're following the steps they always follow. Yeah, you may need to get in there. Ultimately, this is your investment dollar. This is your asset. You can manage very talented vendors, and you can manage them through very very diligent processes. But unexpected things happen. Exceptions pop up all the time. We have whole reports for them.
Sure.
So so ultimately at the end of the day, this is your asset. So you'll have to drive the bus, but hopefully you can rely on your people the overwhelming majority of the time, that you won't have to get too involved too often.
That is some great advice, Neil. I really do appreciate you coming on and sharing your insights with me today. I always do enjoy a chance to catch up with my friend and former business partner and just someone that I came into the industry with. So I really do appreciate continuing to learn from you, just like I did from day one. And thank you for coming on and sharing again today. For those of you that are watching, if you have additional questions you'd like to ask Neil or myself, you can leave those on LinkedIn and YouTube, and we'll be responding to those. Or if you have additional topics you'd like to see us discuss, as someone who has sat on multiple sides of the equation here, always happy to have Neil continue to come back and help us continue to create great content for a great industry. But Neil, thank you again for all of your time and attention today. I really appreciate your insights.
That was my pleasure. Thank you for having me.
And thank you everybody for watching. We'll see you all again soon. Bye.